Welcome again to the Melling Law YouTube channel, where we talk about different estate planning topics relevant to Utahns. One of the questions I am asked quite frequently is, what kind of trust should I have? Should I have a revocable trust? Should I have a living trust? Should I have an irrevocable trust? These are words you'll hear every now and then, whether from other attorneys, from your accountant, from financial advisors. But there are quite a few misconceptions around the terms, and so people say they want one thing, but really they don't understand the implications of that arrangement. So we're going to talk about the difference between revocable trusts, irrevocable trusts, and living trust today. Traditionally, a trust is any kind of legal arrangement that has three parties involved. The one is a grantor, someone giving property to that trust. The second is a trustee, someone with authority to manage those trust assets according to the terms that the grantor stated in the documents. And then we have the beneficiary, and that can be one or multiple people or an institution, but the person who, upon the happening of an event or condition in the trust, will receive trust assets. Those three hats are worn by three different people, traditionally anyway. These traditional trusts, irrevocable trusts, once granted by the grantor, really had to be strictly followed. And the only way for a trustee to distribute trust assets was according to the trust terms to the trust beneficiaries. These were irrevocable trusts because the grantor really didn't have any power to change the trust once it was granted. And there were some protections in that, and there are also some complications. Some time ago, about maybe the 1970s, 1980s, we saw a lot more trusts coming into play in estate planning for the purpose of probate avoidance. And these trusts were living trusts. They became much more mainstream. Maybe that had to do in part with technology, the lower cost of having these things drafted. But whatever the reason, we saw more and more living trusts or revocable trusts being used by middle-class families. And these trusts, the reason why they work the way they do is because those three hats, traditionally worn by three different people or sets of people, instead were worn all by the same person. And what that allows is the flexibility for this grantor to give the trust property to themselves as a beneficiary while they're acting in that trustee capacity. And when all three of those roles are the same, it's really easy to, because you have no legal duty to any of the contingent beneficiaries or the people passing away or receiving the property after you pass away, you have the flexibility to do with what you want with the trust assets. So really for almost every purpose under the sun, whether it's asset protection, liability, tax purposes, titling, for every purpose, the grantor, trustee, beneficiary, this person that set up this trust has all control over the trust assets. And that's really makes things simple. You also lose some of the protections that you would have in an irrevocable trust, but it is very, very flexible. And that's why we see more and more of them being used in estate planning, and that has continued to happen over the last several decades. We're at a point now where the costs to draft a trust are very low. Even some online services can do them. They might not be as comprehensive or contemplate certain types of family issues or asset structures, but truth is you can, for a few $100s, get a trust online for purely probate avoidance purposes. Whatever the reason, these revocable trusts or living trusts are a very valuable estate planning tool, but it is important to know that there are distinct differences. You can check out our website for blog posts about some of the more nuanced differences between revocable trusts and irrevocable trusts, as well as this channel. Feel free to subscribe for future updates, and thanks for listening today. And keep in mind the differences there, and know what you're really asking for when you talk to your attorney.